Chairman. Um, Judge Lee, your analysis of the beloved church's free exercise claim doesn't include, you reached the conclusion that this case was not similar to Lukumi because, as you put it, quote, nothing in the record suggests that Governor Pritzker has a history of animus against religion or religious people. And the order treated churches similar to movie theaters and bowling alleys instead of essential businesses. But I'm not sure that completely resolves the question, does it? I mean, isn't it a little bit different? The right to bowl or the right to watch a movie, isn't that a little bit different than what's protected by the First Amendment?
Thank you, Senator Lee. Clearly, those activities are different. But when I was looking at applying the neutral and general applicability test to determine the level of scrutiny to give to Governor Pritzker's order, I was looking at whether or not the order treated comparable secular activity better than comparable religious activity, or whether they treated comparable religious activity more negatively than comparable secular activity. And so that's where the analysis came from.
But why limit religious worship to 10 people? How could one justify limiting religious worship to 10 people in a facility that could accommodate a larger group while still preserving the 6 feet of distance recommendations?
So, Senator, as I noted previously, since that decision was issued and since the Seventh Circuit affirmed my ruling, the Supreme Court has provided further guidance on what factors a court should consider in doing that comparability analysis. And certainly after, for example, in Tandon v. Newsom, the court talked about comparability and how it should be evaluated looking at the interests, the government interest that the restriction was to further. And certainly at this time, if a case like Castle were to come before me, that is the rule that I would apply.
Sure. No, I understand that. I get that. That precedent has come out since you ruled in that case. I'm just asking about, based on precedent that it was in place at the time, it seems to me fairly apparent that it would matter if a church had more accommodations. What about the church's parking lot being unable to accommodate drive-in services? Does that matter? Should that have mattered?
Thank you, Senator Lee. I believe that Governor Pritzker's order did allow what became popularly known as parking lot services or driveway services. And so I believe the restriction was specifically looking at gathering of church members inside the church.
Okay, so what if the beloved church ran a soup kitchen where the capacity is unlimited so long as people are able to socially distance? At what point would the soup kitchen turn into a religious activity subject to the 10-person limit?
Senator, that is a really interesting question. It is a question that did not come before me in the Castle case. And given the state of affairs now in this country with regard to the pandemic, I'm afraid a question like that may come before me. And as a sitting federal judge and a nominee to the Seventh Circuit, I believe it'd be imprudent to provide my advisory thoughts with regard to an issue like that.
Okay, well, would it matter? What if the pastor led attendees in a blessing before meals were distributed? Would that make a difference?
Again, Senator, with regard to particularly the issue of prayers and the context of prayers, I know that there's a case before the Supreme Court, and there are those are issues that are hotly contested in litigation. And
No,
again, I'm afraid that that's something that I would not be able to opine on today.
Yeah, look, I see I'm out of time, but I'm troubled by this because the minute government gets into the business of saying you're fine if you're operating at this moment as a soup kitchen, but don't you dare pray or you'll be put into a different classification. The minute you pray or we deem you to be operating as a church and no longer as a soup kitchen, you're subject to a 10-person limit. I understand that there's ongoing litigation. I respectfully disagree with your suggestion that the outcome of such a case would be affirmatively in doubt based on that. I mean, I think in that circumstance, we're dealing with a very core, pretty clear and present equal free exercise clause violation. The minute that government gets involved in telling churches how to operate and treating them differently, subjecting them to more restrictive treatment simply because they are operating religious services, that's a huge problem for, not for me, for the free exercise clause. Thank you.
Thank you, Senator Lee. Senator Blackburn. I'm sorry, Senator Ossoff. I note your arrival.
Thank you, Mr. Chairman. Thank you, Senator Blackburn.